If you have ever owned a cat, you have probably done this. You pick up a laser pointer, you put the red dot on the floor, and you flick it across the room, and the cat goes insane chasing it. It is the most ordinary thing in the world. It is also, on paper, a patented invention. On August 22, 1995, the United States Patent and Trademark Office granted patent number 5443036, the title method of exercising a cat. 2 private citizens now legally owned the act of pointing a laser at the floor so your cat would chase it. Nobody sued anybody. There was no trial. And that is exactly what makes this one of the strangest files we will ever open. Because the whole story is what the system approved when no one was watching. Let's read what they actually got. The patent does not claim the laser. That matters, so hold on to it. The laser pointer already existed. The file itself cites earlier laser pointer patents from 1988 and 1990, and older light toy patents going back to the 70s. The inventors, Kevin Amos and Martin Abbott, weren't claiming the device. They were claiming the method of using it. Claim 1 reads, in the office's own language, a method of inducing aerobic exercise in an unrestrained cat, comprising directing an intense coherent beam of invisible light onto an opaque surface to make a bright pattern of visual interest to a cat, and then redirecting that beam out of the cat's reach to make it run and chase. That is the invention. Point the dot, move the dot, cat runs. The specification goes further. It tells you the light should move in the general range of 5 to 25 feet per second. Fast enough to excite the cat, slow enough that the cat doesn't give up. The patent office read that, found it new, found it useful, found it non-obvious, and stamped it. A method of playing with your cat became intellectual property. It is worth slowing down on that word method. American patent law does not only protect machines and chemicals, it protects processes, a sequence of steps to achieve a result. That is how you can patent a way of doing something without inventing any new object at all. And every patent, method, or machine has to clear 3 bars. It has to be new, nobody did exactly this before. It has to be useful. And it has to be non-obvious, meaning a person of ordinary skill, looking at what already existed, wouldn't have found it an obvious next step. The whole question this patent raises, and never had to answer, is the 3rd bar. Is moving a light around for an animal to chase a non-obvious idea? Cats have chased reflections off a wristwatch for as long as there have been wristwatches and cats. But the office doesn't judge the general idea. It judges the specific claim in front of it against the specific prior art in the file. And on that desk on that day, no document in the file said, in these exact words, exercise a cat with a handheld laser, so it passed. Novelty, narrowly defined, is easier to find than common sense suggests, and here is where this file breaks the pattern of every other one. There is no conflict, or rather, the conflict is the one that never happened. Think about what this patent read literally covers. Tens of millions of cat owners, every pet toy company selling a laser dangler, every cat laser gadget on a shelf. If the patent were valid and enforceable, all of them were, in the language of the commentators who later found this thing, technically infringing, using a patented method without a license. That is a joke, of course. No court ever said it. But it points at something real. A granted United States patent is a legal right to exclude others from doing the thing it describes. On its face, Amos and Abbott held the right to stop you from exercising your cat with a laser. So why is there no lawsuit? Because enforcing this patent would have been suicide. The moment they sued anyone, that defendant would have done what Ford and Chrysler did to Robert Kearns: attack the patent itself. And the attack writes itself. Moving a light for an animal to chase is as old as a child with a flashlight and a kitten. The prior art is everywhere. The smart move was never to test it. A patent you never enforce can never be invalidated. It just sits there looking official, meaning nothing. So if there's no trial, where is the ruling? There are 2, and neither happens in a courtroom. The first ruling is the grant itself. In 1995, an examiner at the patent office looked at this application, compared it to the prior art on file, and decided that the specific method, laser, opaque surface redirect out of reach, 5 to 25 feet per second, cleared the bar. That decision is the ruling. The system already spoke, and it said yes. The second ruling came from the owners. A United States patent isn't free to keep. You have to pay maintenance fees at set intervals to hold it alive. Amos and Abbott paid the first one. Then they stopped. On August 22, 2007, 12 years to the day after it was granted, Patent 5443036 expired for non-payment of maintenance fees. It was supposed to run until 2013. They let it die 6 years early. They didn't lose it in court. They didn't sell it. They simply decided it wasn't worth the fee. The method of exercising a cat passed quietly into the public domain, where, honestly, it had always belonged. So what did this patent ever do? Nothing. And that is the point. It never made a dollar. It was never licensed, never litigated, never defended. Its entire working life was as a curiosity. The patent people pull up to prove the system will grant almost anything if you describe it carefully enough. Compare it to file number 1. Robert Kearns had a real invention built from common parts, and he spent 17 years and a fortune forcing 2 carmakers to admit it was his. Amos and Abbott had a far thinner claim, and faced none of that because they never asked the world to respect it. The contrast is the whole lesson. Kearns proved that a strong patent is only as good as your willingness to fight for it. The cat laser proves the opposite corner of the same truth. A patent you never enforce costs you nothing and protects nothing. It is a certificate, not a weapon, until the day you draw it, and they never drew it. That is the quiet absurdity at the center of this file. We imagine the patent office as a gate that only real inventions pass through. But a granted patent isn't a verdict that something is brilliant or even that it's truly new. It's a verdict that nobody at that desk on that day stopped it. The test of whether a patent is worth anything doesn't happen at the grant. It happens the first time the owner tries to use it against someone, and most patents, like this one, die before that day ever comes. Amos and Abbott owned the act of playing with your cat for 12 years, and then let it lapse for the price of a fee. Next time a patent that was the opposite. A single broad claim its owner enforced against an entire industry, suing thousands, until the courts finally asked whether the thing had ever been an invention at all,